Showing on this episode of Law Weekly, a conversation on resolving the disputes over the authority to regulate terminal operations and the export of crude oil, the ambiguities in the Petroleum Industry Act, and the conference of the Nigerian Bar Association section on business law scheduled for Wednesday, July 5th to Friday, July 7th in Lagos. We talk all of these issues with Dr. Adeoye Adefulu, a partner at a leading business law firm, Odujiri and Adefulu, and the chairman of the NBA section on business law, NBASBL. Dr. Adefulu has over 25 years of professional experience in the fields of petroleum law and policy, electricity law and policy, corporate and project finance, amongst others. He's been involved in many landmark transactions and projects in the Nigerian energy sector, such as the privatization of power generation and distribution companies, the acquisition of oil and gas assets, the financing of gas pipelines and power plants, and the drafting of legislation and regulations. I began our interview with his thoughts on the whole issue of removal of fuel subsidy and perhaps how he thinks it could have been better handled.
I think it's very, very challenging, the issue of subsidy, because there's a lot of, it affects people really directly. Your transportation costs have gone significant. Many organizations that actually use fuel for their generating sets, obviously those costs have gone up. But in order to kind of understand, to answer your question properly, it's probably useful to go into a bit of a background as to how we came here anyway. And I remember in 2015 that lots of the advice that was given to the incoming president at the time, President Buhari, was to put an end to the subsidy regime. The situation that we had was I would say, unsustainable situation, where we were importing lots of this PMS. And PMS is the ordinary fuel that we use in our cars every day. But we're also importing other petroleum products, but there were no subsidies on those. And the challenge with the subsidy situation was you maintained a price for PMS whilst the factors that influence the pricing of PMS kept on rising. So we had the Ukraine war, etc., which led to an increase in the price of crude oil, which makes up 60-something or 70-something% of the component of the price of PMS. And so it was a situation where it was unsustainable. And then you have to also go back to the context of the Petroleum Industry Act, which was passed in 2021, I believe. In 2021, had already provided in law that within 6 months of the passage of Petroleum Industry Act, which will have been February 22, that petroleum products, all petroleum products, will be sold at basically reflecting the economic costs of those products. So there was already something in law, and coupled with the fact that there really wasn't a budget for it. So the question is, was it the best way? I think, when I look back, my answer is that I don't know if there is a good way to remove something like this. It came as a shock to the system, but I think if you had waited for another month or another 2 months with consultations, etc., I suspect that the political will to do it will have slowly ebbed away. We've tried to remove subsidy. Look at 2012 under the Jonathan government and the riots that followed. And under Obasanjo, under various governments, we've always had this challenge about being able to do it. So I don't think that any way of removing the subsidy would have been seen in quotes as a good way. It just had to be done. And this was ripping the Band-Aid from this wound that we were suffering.
Doc, the ambiguities in the PIA, because you've already talked about the PIA and the dispute over authority to regulate terminal operations and the export of crude oil. I know you've written an article about that, but What's the alternative approaches to the adversarial position that's already taken by the regulators?
So that's an interesting challenge. I think one of the petroleum industry bill, the process of passing it went over. I mean, it started really in 2000. And then in 2008, the first piece of legislation was introduced into the National Assembly, and through various forms of the National Assembly, went from different forms of PIB to the other. Eventually, we got it passed in 2021, as I mentioned earlier. But one of the challenges in implementing it has been that we've noticed that there are lots of ambiguities in the PIA. And that ambiguity has meant different things. For operators, clients come on a daily basis, seeking clarification of what exactly is the position of the law. And that the ambiguity is not just an ambiguity for commercial operators or lawyers like myself. It looks like it's an ambiguity that is facing the regulators, the industry regulators themselves. And to put this in context, when we're talking about the passage of the PIB, there was a debate as to whether we should have a single regulator that would regulate from the upstream, which is where you extract the oil and gas, etc., and you consequently sell it off, to the midstream, which is really made up of the transportation, the refining of petroleum products, etc., and the processing of gas, to the downstream, which is really, what you and I deal with on a daily basis, buying fuel from the petrol station, etc. So to have one regulator that regulates along that chain, or to split the chain, where you have one for the upstream, one for midstream and downstream. In fact, there were other iterations as well, but the central debate was around this. And the challenge and the main argument, first, the policy document, Nigeria's policy, petroleum policy, which the Federal Executive Council approved in 2017, I believe, actually made the argument for a single regulator. And the principle around a single regulator was that the regulator could look through the value chain, right? And you can harness the synergies. And then that's on the positive side. But potentially on the negative side was that you could avoid a situation where regulators are kind of, would I say, for lack of a better phrase, butting heads with each other. And that's a challenge we've actually seen, and not just in the petroleum industry, but in other sectors as well. We have regulators sort of vying for control over a particular sector. And the oil and gas sector in particular is actually quite attractive, generates a lot of revenue, etc., etc. So we have the challenge. Now, when we go to the ambiguities in the PIA, and I'm trying to make this as transparent as possible. One of the challenges we've seen from the regulator side is that the regulators, the upstream regulator and the midstream and downstream regulator are currently in, at best, what I would call a conflict. And where you have these two elephants fighting, and that was, a parable that I actually shared in that proverb I shared in my article. When you have two elephants fighting, it's really the grass that is suffering, and the grass is made up right now of the industry, where the NUPRC asserts control over export terminal operations, and export terminal operations are where you actually take the crude to sell the crude into the international market, and then MDPRA is also asserting control over those terminal operations. From a practical perspective, I want you to understand what that means. It means that the way the regulators assert control is the regulators are there in person. They would approve your export of crude. If they don't approve, frankly, you can't export crude. So from a practical point of view, you may be in a situation where you have two regulators who are on site. One regulator approves your export, one regulator declines the export. And recently, one of the companies, it was reported in newspapers that one of the international oil companies was reported by one of the regulators to the chief of defense staff as saying they were illegally exporting, I think it was petroleum products.
Because one regulator had approved and one had declined.
Exactly. And so that is an unsustainable situation. First, it's an embarrassment to that international oil company because, as far as they're concerned, they've done what they are meant to do within the ambit of the law. And if if one regulator gives you approval, it's so, for the other regulator to then, report you to the intelligence or the defense forces, that puts you in a terrible position. And so for me, I think that the government needs to take a very strong position on this. By under the PIA, the minister has the right to issue a directive to the agencies as to how they want them to operate and cooperate. And so I think that the president, who has all executive powers vested in him under the Constitution, has a right to issue such a directive. But beyond the issuance of the directive, I think that we need to get to the judiciary to really sit down and interpret the position of the law. We know that common sense tells us that the law wasn't there to create a situation where two regulators are regulating the same exercise. So I think both regulators are clear about that situation. They don't want two regulators regulating the industry. But we need someone to clarify, what is the sensible position of the law, which one of the regulators is meant to have control over the affairs. So I would suggest that either of the regulators or both of them go for judicial interpretation. And if they don't do that, that the operators in the sector should take up that opportunity. And finally, I think that it is important that not just this ambiguity, but several other ambiguities in the Petroleum Industry Act, that the legislature should sit down and look through that piece of legislation and make it clearer.
I hear what you say about some of these ambiguities, but as the chair of the NBA section on business law, what is the section doing about some of these issues? I know that you have a conference coming up. There's been a lot of buzz and talk about that conference, but are you inviting the lawmakers to that conference? Will some of these issues be up for discussion at the conference?
I mean, certainly the conference which comes up in July is about the business landscape, the laws, policies, law, policy, and regulation. The priority is really for the incoming government. The government is a major stakeholder in this conference. Our government has always been. We work in partnership with the government and lots of players. We don't, unfortunately, have ministers at this time, but lots of people at the regulatory level and sub-ministerial level will be invited, are invited, and are coming, have confirmed their attendance at the conference. And one of the things that we're very focused on at the Nigerian Bar Association section of business law is ensuring that we're not just having conferences for a talk shop. Our conferences are result-oriented. So what are the things that we've discussed? What are the issues? What are the problems? How do we ensure that the government gets our feedback on what those issues are? And beyond our feedback, how do we ensure that they implement? So in the course of the conversation and the course of the discourse, the issues around ambiguities, potentially around the PIA, will come up. But we are already engaging, even before the conference, with the regulators. We will, through our relationship with the NESG at NASBA, we will also engage with the National Assembly and bring these issues around ambiguities to their forefront.
Interesting. The NBASBL Conference is something that a lot of lawyers look forward to. What would you say sets this year's conference apart from previous editions? What can attendees and participants look forward to?
One of the things about the NBASBL since its inception is that we have been known for delivery of good and excellent conferences. But beyond this conference, one of the things that we've kind of held on to is to create an institutional mechanism on the implementation of the conference discussions.
Yeah, because implementation is key.
Yes, so we've always informally, followed up our conference discussions, but we've never created a formal mechanism for doing this. So we've now created it, and the person who's holding the position of vice chair of the conference planning committee for this year's conference will has that execution mandate on him. So we will be picking on a number of themes, probably 2 or 3, from the council level that we are going to follow up as SBL Council, and we will report on at next year's conference.
Thank you for staying tuned. Now, what should businesses of today and tomorrow do as actors in international law? And more importantly, how can businesses influence good practices? These and more formed part of the discussions at the recently concluded 150th Conference of the International Law Association in Paris. The president of the International Law Association Nigerian branch, Senior Advocate of Nigeria, Professor Damilola Olawiyi, a professor of energy and environmental law and currently a United Nations independent expert representing Africa on the UN Working Group on Business and Human Rights, joined other discussants to share his thoughts on these and other issues at the conference. We have some of the details up next. October 13, 1873 saw the birth of the International Law Association, ILA. 150 years after, it's time to celebrate a milestone anniversary of the association, which now has over 4,000 members with 61 national and regional branches spread over 5 continents of the world. The French branch hosted this milestone 150th anniversary at the City University in Paris, which had the theme Build Tomorrow. On June 18, participants were welcomed to the opening ceremony which held in this hall. It's a hybrid event which had many more participants joining online. The event was moderated by the honorary president of the French branch and president of the organizing committee, Catherine Kessijian. It was an evening of frank conversations, spiced with a display of French culture, music, and entertainment. One after the other, speakers took to the podium to welcome participants to the event, with some speaking in French and others in English. The executive chair of the ILA since November 2022, Professor Christine Chinkin, a professor of international law, goes down memory lane.
When in 1872 the arbitral award determined that Britain must pay a large sum of gold as reparation to the United States, Prime Minister Gladstone described the process as, to quote, exemplifying the means by which 2 civilized nations could settle differences without either having to admit being in the wrong, 2 proud nations going in peace and concord before a judicial tribunal. And then the following year, in October 1873, a small group, including lawyers, philanthropists, diplomats, representatives of peace associations, met in Brussels, where they formed the Committee for the Reform and Codification of International Law, renamed in 1895 the International Law Association. And so it's from that meeting that we are here today in 2023, celebrating the association's 150th anniversary. And I do think we have a lot to celebrate.
If you look to the reports of 80 biannual conferences of ILA throughout its history, we can confirm the contributions made to the treatment of all the relevant issues of international law over this century and a half. We are living now in times where the pillars of world order that we took for granted are under attack.
One of the breakout sessions of the conference featured a discussion on businesses as international law actors. The president of the International Law Association Nigerian branch, Senior Advocate of Nigeria, Professor Damilola Olawiyi, joined other panelists to share his thoughts on the topic. The Secretary of the Nigerian branch, Clement Osuya, was also in attendance.
First, we think businesses can use their leverage over their suppliers and subcontractors to promote good behavior, especially in the area of sustainable consumption, sustainable packaging, use of eco-labels. For example, Microsoft recently released its supplier social and environmental accountability manual, in which it says clearly that all its suppliers must demonstrate that they are reducing water and energy waste and that they are promoting sustainability. And without demonstrating that, they will no longer act as suppliers for Microsoft. I think that's a good way of promoting sustainable consumption, and that's a good way that a business can act as an influencer for good conduct. Many of the things that we hope to achieve, whether we're talking about advancing the SDGs, will require money, and lots of money, as a matter of fact. So the key question we ask is that how can financial institutions, especially development financing institutions and multilateral development banks, how can they be at the forefront of ensuring that the financing of infrastructure development does not exacerbate human rights abuse? Of course, we would like to see businesses and financial institutions saying that we will not finance any project that does not align with the UNGPs or with international human rights law.
If we take a look around, we are doing business in a highly uncertain environment. We are doing business with increasing risks in multiple domains, particularly in cyber, in data, many others. We see increasing waves of protectionism, numerous legislations being enacted here and there, and we are doing business in a global economy. So we cannot do business in a global economy if we don't have everything we need to manage the company in a consistent and current manner worldwide.
The conference was rounded up on June 20th, with participants acknowledging that this is a difficult time for international law. The consensus appears to be that in looking to build tomorrow, there's a need to look back at the origins of the association and join hands with many others in reclaiming peace and justice in the world. And just before we go, let's quickly do a recap of some of the top trending stories from the courtrooms.
We begin with the report that the judiciary in Taraba State is asking Governor Agbukefas to intervene in rejuvenating and empowering the judiciary to function as watchdog of the society for speedy dispensation of justice to all. At a courtesy visit on the governor, the chief judge of the state, Joel Agia, lamented the dilapidated courtrooms they operate in, stressing that most of the magistrates, upper area courts and area courts outside the state capital are sitting in rented apartments with pending quit notices. According to him, judicial officers in Taraba State lack official vehicles, do not go for annual vacations, workshops, seminars, and lack running costs.
I myself standing before you, Your Excellency, the last vehicle I had was in the year 2008. Myself and my Lord Justice Adi, who is the second in the High Court bench. Issue of infrastructure, Your Excellency, most of our court buildings, particularly those outside Jalingo, are in the state of dilapidation. Particularly the high courts in Jembu and the one in Taku.
After listening to their plea, the governor gives his assurance of unflinching support to ensure optimum function of the judiciary in the state.
I will do all my best to make sure that the judicial arm of government function the way it's supposed to function. The little things that we need to do, we have started, and I want to assure you that the area of your mobility, official vehicle, which is mandatory, your accommodation, and even the court that we are renting. We are going to build new courts in all those areas.
In other news, a family court sitting in the Iyagoku area of Ibadan, Oyo State, has ordered the remand of skit maker Maruf Abdullahi, popularly known as Trinity, over alleged sexual exploitation of a 10-year-old girl. He was arraigned alongside Isiaka Ahmed, 40, and his wife Rofiat, 29, who are parents of the victim, on a 2-count charge of conspiracy, sexual abuse, and exploitation. The prosecution counsel, Inspector Oluwakemi Arowoshaye, had told the court that the 3 defendants conspired together to sexually abuse the girl. According to her, the offences are contrary to Section 35, subsection 1 and punishable under Section 35, subsection 2 of Oyo State Child Rights Law, 2006, and Section 516 of the Criminal Code Laws of Oyo State, 2000. Magistrate Patricia Adetuibi, who did not take the defendant's plea for lack of jurisdiction, said that the case file had been sent to the Oyo State Ministry of Justice for the advice of the Director of Public Prosecution. And we round off with the report that the Socio-Economic Rights and Accountability Project, SERAP, has asked the leadership of the central bank to remove the provisions in its regulations directing banks to obtain information on customers' social media handles for the purpose of identification. The rights group believe the CBN's directive violates Nigerians' rights to freedom of expression and privacy and is inconsistent with the rule of law. The central bank had mandated banks and other financial institutions to implement and comply with the mandatory provisions on customers' social media handles in the Apex Bank's regulations, a policy SERAP is strongly opposed to and has threatened legal action. In a letter, SERAP argues that the CBN ought to contribute to the advancement of respect for the rule of law and human rights in the discharge of its statutory functions and not violate it.
And that's the program for today. If you missed any part of it, you can find it in past episodes on our YouTube channel. Do also give us feedback via any of our social media platforms. I'm Shola Shieli. Thank you for watching and see you next week.